Thanks for tuning in today. I'm joined by attorney Frank Borgese of the law offices of Graham and Borgese, a consumer debt defense law firm serving both New York and New Jersey. Thanks for being here, Frank.
Thank you very much for having me. I appreciate it.
So, why don't we start off by you just telling the listeners a little bit about what your firm does to help consumers?
Sure. Well, Graham and Borgese, we've been around for a decade plus, and we help consumers dealing with debt issues. Really, we deal with all phases of debt defense. So if somebody's dealing with an account that just recently went into default, we can help them. We help people in litigation and even people dealing with judgments and enforcement of judgments. So we really kind of run the whole gamut of debt defense to try and help people improve their finances.
Okay, all right. Now, I spoke to your partner, Chris Graham, last week, and we really focused on debt settlement. So with you, I'd like to talk about debt lawsuits, if that's all right.
Sure.
All right, great. So let's just start from the beginning here. Walk me through the process. I've just found out I'm being sued over a debt, and I call you. What happens from there, and what should I expect? What do you need from me to help you help me?
Well, as with any court proceeding, we start to analyze deadlines that may apply to your situation. We really try to explain what your options might be to resolve the debt, how procedurally to respond to the lawsuit to make sure a creditor doesn't get a judgment against you without your knowledge. And we try to lay out for any person calling our office a plan of attack, something that we think would, best meet your goals and allow you to, eliminate the stress and anxiety that, litigation can bring.
Okay, all right. Now, let's say that, I haven't been properly served yet. Can I just ignore the server and just avoid the whole thing? Or what if I'm not served properly? How does that work?
Well, anytime a lawsuit is filed, the creditor is required to provide you notice of the lawsuit to give you an opportunity to defend the case. Many times the process servers that are hired to complete the service may not have your correct address, or they may have trouble communicating with you directly. And it's important to know that there are different types of service. A lot of people think that in order to be officially served, they have to have the papers handed to them personally. Something you might see on a movie or a TV show. But in New York, there's actually several different ways that you can be served, and each of these ways, if completed, trigger the timeline and the countdown for you to respond to the lawsuit to prevent a judgment from being entered. So, for example, there is that personal service where somebody's going to hand you those papers. If that happens, you generally speaking have the least amount of time to respond to the lawsuit, find an attorney, or do it yourself. But another form of service that oftentimes will take place is called substituted service. And that's if, for example, somebody goes to your house and ring on the doorbell, and a spouse or a child or a relative or friend, somebody of suitable age and mind, is actually at your house. They can actually collect service on your behalf, whether they like to or not. And, as you can imagine, that can be scary, because whether or not they're going to pass along to you that those papers were received, you can't be certain always.
Sure.
And now, there's an extra requirement when something like that happens, that the creditor mail a copy of the papers as well. It's kind of the court's way of making sure that, multiple opportunities for this notice to be passed along are made. But a lot of times people get one, mailed to them, and they think that there's something else that has to be done. And so, that's something that anybody that might be listening wants to pay attention to. If they get papers, chances are that it's part of the bigger process of service, and you want to make sure that you're reaching out to an attorney right away if possible. And the last form of service that will many times happen is called nail and mail service. And you mentioned earlier, can I avoid service? Maybe prevent them from giving me the paperwork. Well, the courts in the state, they realize that this may happen quite a bit, and they don't want to prevent creditors with legitimate claims from pursuing their debts. And so if they've exhausted all their other efforts to try and personally serve somebody or give it to somebody of suitable age and discretion, they can actually tape a copy to your door, tuck it in the handle of the door, and then mail a copy. And so those
There's really
are
no
the different ways
to avoid it.
Right. I mean, you might be able to prolong the process, but it's inevitable. And, many times what we find is that the process servers, they want to get credit for serving you, so they may indicate that they think they served you. And, that's something that can, be to the detriment of the consumers out there in New York or New Jersey that are trying to defend the cases that are brought against them.
Okay. All right. Well, that's a lot of great information there for anyone who is thinking they could just avoid the process by hiding. So now what happens if somebody just ignore the lawsuit altogether? They just don't want to deal with it. They figure it'll just go away. What risks are they running?
Well, I think it's something that happens from time to time. Debt situations they can be really stressful. If you have a situation where you don't think that you have the funds to resolve the debt or hire an attorney, you might think just ignoring it is the best bet. But ultimately, it's the same way in sports. If there's a game scheduled and one side doesn't show up, the other one wins by default. And so same thing in the court system. If you've been given notice and you just choose not to defend the case, the court takes that as you're guilty or you should be held liable for the damages being sought. And so that allows the creditor to go ahead and try to do various methods to enforce the judgment involuntarily against you, like wage garnishment, frozen bank accounts, liens on properties, and that can be that much more, stressful and cause that many more problems for the person that tried to avoid the litigation in the first place. Okay, so
it sounds, like ignoring this problem is only going to make things worse. You mentioned judgments, and that's something we can talk about, when you come back in another episode. But, you basically don't ignore it. Call an attorney because you're only going to make things worse. So, now, a little bit ago, you mentioned something about an answer. Can you explain to the listeners what an answer is? And you said I think you mentioned you could do it yourself. Could you just talk about what it is and if it's something that they really should have an attorney do as opposed to doing them themselves?
Sure. Anytime a lawsuit is filed, the documents that are filed with the court are called a summons and complaint. And the summons, as it might suggest, is directing you to come to court to defend the case. And the complaint is where the party that's suing you is raising all of the facts that they think entitle them to a judgment against you. And so anybody that's been sued has an opportunity to answer the lawsuit. And, this is where you as a defendant would raise any legal defense or legal argument or any, questioning regarding the factual allegations that are advanced. And, so it can be done by an individual, but as, with many things in life, if you don't have experience or expertise in the field, or just in legal terminology and legal defenses, what may happen is that you may miss an opportunity to raise a defense or an argument, and in litigation, if you fail to raise an argument, it's deemed waived. So you want to make sure that if you have an argument or you feel that there's something that may prevent the creditor from getting a judgment, you want to really make sure that you speak with an attorney, because at that point we can analyze for the individual all the different legal arguments that could be raised to preserve them. The last thing you want to do is find out that you had a good argument to raise, you didn't do it, and now you're prevented from bringing it up after the fact.
Okay. So I guess, my answer can't be I don't have money. It has to be a legal defense, and this sounds like something that you would obviously want an attorney to do.
Yeah, and I can't tell you how many times over the years we've had people come to us after they've attempted to file an answer on their own, and that very frequently is the quote-unquote answer that they file with the court, which is, I know that I owe this money, unfortunately I don't have anything, or money's really tight and I can't afford to pay this. The court looks at that, and all they see is a creditor saying, we gave you a credit card, you incurred charges, you failed to pay us back, and this is how much is owed. There's no legal defense in I don't have any money to pay this back. What the judge is going to do is order the judgment. And, judgments in New York last for 20 years. Mm-hmm. They grow at 9% interest until they're repaid, and they can be renewed once for another 20 years. So wow. You might not have money now to pay your debt, but a creditor might bank on, maybe in a year, maybe in 5 years, maybe in 10 years, you will have the resources to pay this debt back. And oh, by the way, the debt might double in that time. So it's one of those things you really want to try to spearhead as early on in the process as possible. And that being said, we do help people that do discover these judgments 10 years down the road, or they go to sell a property and they discover there's a lien, or their bank account's restrained 5-6 years after the judgment's been entered. So, we can help anybody no matter where they are, but as a general rule, as bad as you think things might be at the moment, the more time that passes is generally the worse things can get.
Yes, that's true with a lot of bad things in life. If you ignore the problem, right, it usually just doesn't go away. Now, in relation to the lawsuits and even judgments and just debt in general, can't I just file bankruptcy and have everything go away? Does that not work that way?
Well, bankruptcy doesn't discharge every type of debt. I'm sure everybody that might be listening has experience with student loans in some way, shape, or form. Student loan debt, although there's been some suggestions that it could be discharged, in practice, student loan debt cannot be discharged. And so, a lot of times people are doing the equations of, can I get rid of my debt through bankruptcy and improve my financial outlook? I'll take a hit now to make things a little bit easier for myself and my family. But student loan debt tends to be some of the largest payments that people have. And, you might have some credit card bills out there that are much, much smaller percentage of your overall debt. So bankruptcy doesn't always make sense in the grand scheme of things, because not every type of debt can be discharged. And then additionally, we get it all the time. People will say, well, maybe I should look into bankruptcy, but there's a certain realization that bankruptcy trustees, they're looking into your financial past. They're looking into your current finances, your household, to determine what kind of resources are available to you, and they're looking ahead as well. So, a lot of times people will go into a bankruptcy thinking that it's going to wipe the slate clean, and instead it ends up being a very, very difficult trying time for them, and we try to help people avoid that and improve their finances right away by settling or defending the lawsuits outright.
Okay. Yeah, I mean, obviously, I think bankruptcies last, is it 7 or 10 years on your record, hurt your credit score. So, yeah, if there's an opportunity to take care of this immediately and avoid that, that's probably preferable to most people, I would assume. So,
right.
Now
and
you mentioned...
if you own assets, depending on what kind of bankruptcy you're doing or what exemptions exist, some people are not prepared to give up certain assets, whether it be a home or vehicles or things of value to accomplish that.
Yes, of course. Now, you mentioned a little, just a few seconds ago, something about settling. If I'm being sued, is there an opportunity, as the lawsuit is started, to put an end to it and come to a settlement, or once the lawsuit gets started, are these debt collectors, do they want to see it to the end? Or is there some sort of chance to maybe come to an agreement and come to a settlement on the debt?
There's a couple points. There's always an opportunity to resolve a lawsuit and prevent a judgment from being entered. I think it's always something that I'm focused on because I do it exclusively, is trying to figure out the angle, the explanation, the motivation for every single client that we have to get that result and to convince the creditor that it makes sense. And, so I think there's always the opportunity for resolving the lawsuit and preventing a judgment from being handled. But at the same time, one of the things that I do see quite a bit is people will reach out to creditors after being sued, and they think that they're maybe working out an agreement, and they kind of lose focus or sight on the procedural aspect of litigation, and so they may not respond to the lawsuit. They may not file the answer. They may not, worry about the deadlines involved, and, they can be shocked to discover we were in talks, but you got a judgment against me anyway. What happened? And now the creditor has gained an upper hand, and the leverage is completely shifted. So yeah, absolutely, there's an opportunity for resolving the accounts, even if the lawsuit has been started, but it's vital, as any matter of course, to try and respond to the lawsuit formally so that you can prevent a judgment by being entered against you by default. Okay.
Now, what would you say to someone who told you, they didn't think they could afford to hire an attorney, your firm, whatever it may be? They don't think they can afford a defense. What do you say to someone who says that to you?
We have helped people of all different walks of life with all different types of financial situations. We represent people that are dealing with financial issues. It's a conscious decision that we've made to help people dealing with these types of very stressful situations. And part of us doing that was knowing that we'd have to make our fees affordable to everybody, and we have options available to help people pay our fees, whether it be payment plans or we structure our fees in such a way that we earn the fees that we charge. Many attorneys, you come to them, you pay a huge retainer fee, and good luck. Maybe we'll do a good job, maybe we won't. At our firm, we really sit down from the very first consultation to try and get an understanding of the individual's financial situation, what their goals are, and then we try to tailor a plan of attack to resolve their debt, and we make that work with our fee so that every person that comes to us can, afford to get quality legal representation. And at the end of the day, we have a long-standing track record of saving our clients money, stress, anxiety, and I think that it may sound cliche, but you almost can't afford not to hire an attorney when you're dealing with these things, because just a couple mistakes along the way, it can be costly in terms of your stress, your anxiety, your health, but also in terms of damaging your credit for a decade, and dealing with the effects of enforcement and interest and just the balance of the debts that are being collected. So we can help anybody no matter what the circumstances. We try to really tailor our fees and our strategy to make it an excellent experience for anybody that comes to our firm.
Wow. And correct me if I'm wrong, but I also believe Chris had mentioned that you guys offer even payment plan options. And forgive me if you did mention that. I may have missed it, but that's another way. That's another way you make it easier for your clients.
Absolutely. I mean, we've been doing this a long time, and we realize that people don't have a big pile of money sitting around waiting to pay an attorney to try and settle their debts. So, we set our fees with our clients, and we work out payment plans that fit their budget, and it's all part of the big plan, the big strategy that we implement about not only, getting them quality representation, but how are we going to get them to save as much money as humanly possible with their debt. So yeah, we do payment plans for our fees, and many times we're able to prolong litigation, for example, or settlement, so that maybe they don't have to worry about paying our fees and a settlement at the same time. That a lot of times is a concern of our clients. Well, how am I going to pay you and pay the creditor? But many times we're able to, to delay the settlements and buy the person time to get their finances situated. And it just, those types of things, they can really improve somebody's ability to get a good settlement in place.
Yeah, I mean, it sounds like you guys really, go out of your way to make it as easy as possible for someone to afford legal defense when it comes to debt. So, I think someone, would be crazy not to give you guys a call and see what you can at least do for them. Let's end this on a personal note. Why don't you tell the listeners a little bit about yourself and how long you've been practicing and why you chose this area of law?
Sure. Well, I've been practicing for over a decade now, and I'm based out of our Western New York location, but I'm admitted in New York and New Jersey. And, really I got into this practice area because out of law school I knew I wanted to help people that didn't necessarily have a strong voice and needed representation to protect them from aggressive, companies and parties. And right out of law school, I began suing debt collectors that harassed people. And, that was something that I could just see firsthand how stressful and upsetting and emotionally draining it was for the people involved. And obviously, in all of those situations, you're getting to beyond the harassment that was there. You were seeing the struggle financially to make ends meet, to provide for family members, to to go to work every day and make money, to know that you're still falling short and you don't know where the end is in sight. Because I was able to do that and bring so many cases in federal court representing these individuals, I saw firsthand that there was a really significant need for an attorney to do this, but not do it as like a secondary thing. Like, hey, I'm doing real estate, I'm doing, I'm doing personal injury. What's that? You got that lawsuit? Yeah, I guess I'll take it on. People need somebody to actually take the time and make it a priority. And that's what Chris and I really wanted to do. And so, it's been the better part of a decade now, helping people in New York, and now, newly admitted to New Jersey, we're doing the same for people there as well.
Yeah, and I think we should, reiterate the fact that this is all you do. This is your focus, consumer debt defense. You aren't doing any of those other things, as you said, real estate, any of that stuff. So when someone comes to your firm, they can expect that, all your focus is going to be on, debt, consumer debt, and you won't be distracted by other cases coming across your desk.
Yeah, I mean, we all have friends who are doctors, right?
Yeah.
And there's always that motivation. You have your foot's bothering you, so you go to your friend who's a doctor and you start asking them, and they're like, "Well, I'm not a foot doctor. I'm not a podiatrist. I do, ear, nose, and throat. I don't know anything about that." And people a lot of times will think, "Well, you're a doctor. You should know everything there is to know about the body and everything there is to know about medicine." That's what attorneys. It's very similar in that we understand legal terminology and procedure, but there's different types of courts, there's different types of procedures, different laws, and everything is different based on the legal issues that are involved. And, focusing our efforts on debt defense, we, over the years, have just touched upon so many different topics, and having that experience and that knowledge, a lot of times we can draw upon all those different experiences to really put together an excellent, argument or defense to represent our clients, in the best way possible. So, if anybody has a debt issue, I would encourage them, as you said, to give us a call. Our consultations are absolutely free. Many times our consultations may take a few different calls or different, a couple of different times to go back and forth, because we want to do a very thorough job of investigating your situation and providing you a plan of attack. So we don't make like a 5-minute analysis that, we don't want to spend time on your case like some attorneys might be, telling their potential clients. We really put in a lot of effort, because at the end of the day, our focus is to really provide that assistance to get our potential clients or our clients to the finish line, which is getting rid of these debt-related issues once and for all.
Exactly. So let's get that number out there where people can call you for a free consultation. It's 888-668-9071, and the website is Graham Borgese, that's BORGESE.com, GrahamBorgese.com. Frank, it was great having you here today. You gave us a lot of insight on your area of law and how your firm helps consumers deal with debt-related issues. So it was a pleasure talking with you. I'm sure we'll have you back soon. You have a great day.
Thank you very much. I appreciate it. Take care.